Oftentimes, clients come to our firm when a family member or friend cannot get out of jail because their bond is too high. Well, what does that mean? In state court, whether it be in Hillsborough or Pinellas Court, Pinellas County, they have a designated bond amounts for different charges, and anywhere from $500 on a DUI case to upwards of 10, 20,000, 50,000, 100,000, even higher, depending on the severity of the charge or charges in a case. So what can you do is clients oftentimes will hire us to file a bond motion on their behalf. And what we mean by bond motion is we're requesting a significant reduction in their bond so that they can be released from jail and at a more affordable amount. So what factors do courts consider when whether determining whether or not they're going to reduce the bond amount? They want to see a few things. Number one, actually, what are the allegations itself? What is the evidence that they have against the person? Number two, does that individual have strong ties to the community? Meaning, are they a lifelong resident of Florida, Hillsborough County, Pinellas County, wherever the county that the bond motion is occurring? Do they have family ties to the area? Do they have loved ones, family, a wife, husband, siblings, mother, father? Are they employed? Do they have a job? All of those are ties to the community that the court will consider. Another factor courts consider is, does the individual that you're trying to get the bond reduction for have a prior criminal history? Courts obviously are trying to determine if it would be a public safety issue if they were to release somebody. And if somebody does not have any prior criminal history or limited criminal history, that could be a factor in the court reducing the bond amount. Those are all factors, generally speaking, that can be raised, and we've successfully raised many times on cases where the bond is very high and our client or our client's family can't afford to post the bond. We're talking about bonds in excess of 100,000, 200,000. I've even dealt with bonds in excess of 700,000, 800,000, even up to $1 million. Obviously, families, friends can't afford that. That's very expensive. And while an individual is sitting in jail, they can't work, they can't aid their defense. So what we do is we file bond motions based on the factors that we enumerated and argue to a court that this person has strong ties to the community, no prior or limited prior criminal history. The allegations are certainly contestable and fightable in court, and they should have the right to be able to bond out so that they can continue to maintain employment. Because essentially, in all criminal cases, you are presumed innocent. You are presumed innocent. You cannot just be jailed indefinitely while your case is pending under most circumstances. So in sum, that's why it's important to hire an experienced law firm like Stechschulte Nell. Myself, I have 17 years experience. My law partner has 15 plus years legal experience. So we have a combined 30 plus years legal experience. And I myself am a former prosecutor and a board certified criminal trial attorney. And we like to use that experience in helping our clients get significant bond reductions in cases.